Welcome to Case by Case. This is a podcast series brought to you by Luke Zadkovich and Calum Chain of Xyloploid Zadkovich. Welcome, Calum.
Hey, Luke. How are you doing?
Good. How are you?
I'm good, thank you. Another interesting case. We're looking at some new issues today that we've not looked at in some of these in our previous case by case episodes, which is always good.
Yeah, jurisdiction always gets my juices flowing, so looking forward to getting into it. For those of you who are joining us for the first time, the way that we run these podcasts is that Calum and I each read an English or a US legal decision, or indeed other jurisdictions as well. We read the case separately, we don't talk about it, form our own views, and then jump on the podcast, hit record, and start talking. So that's what we've done today. We've not discussed this case before. What did you make of it, Calum?
I thought it was very interesting. I thought these are issues that we see so often in the world of international trade, whether it's shipping disputes or commodities disputes. The case touches on arrest, it touches on the kind of conflict of laws and the application of jurisdictional principles about which court is the appropriate court to bring a dispute in. There's a lot. It also touches on jurisdiction provisions and the way that the court's going to interpret how broad a jurisdiction provision is, and I think that's quite interesting, especially in the shipping context, where in the recap of some of the charge party agreements, a jurisdiction provision can be as simple as, Ing law, London Arb. So trying to interpret that and pull out what that actually means as an arbitration agreement is always helpful to go back to some principles from case law to sort of see how those jurisdictional agreements will be considered by courts.
Yeah, absolutely. The jurisdiction clause question I found quite interesting, and really was one of the takeaways from my perspective. What particular words mean in a jurisdiction clause, and how broad or narrow that clause then is. Before we get into the facts of it, though, Calum, did you pick up that the name of the vessel in the subject charter party, not the arrested ship, but the subject charter party of the dispute, was called the DIVINEGATE?
I did.
Now, are you aware of a 2013 Japanese anime game called DIVINEGATE?
I'm not, I have to confess.
I didn't think you would be.
Do you think the game was named after the vessel?
Well, that's a very good question. Or was the vessel named after the game? The interesting thing on this was I had no idea about this. I just punched in DIVINEGATE into Google to see what popped up, and up came this Japanese mobile game. And then I couldn't help myself but click on Wiki to see what the game was about. And this is the plot. And I thought it was a nice little aside for some levity. The plot of DIVINEGATE is: the living heavens and underworld become connected after a divine gate is opened, ushering in an era of chaos where desires and conflict intersect. Only when the World Council is formed are peace and order restored, and the divine gate becomes an urban legend. In that world, boys and girls deemed fit by the World Council are gathered, who aim to reach the gate for their personal objectives. Those who reach the gate can remake the world and even the past or future.
Well, it sounds suitable for a judgment of the Commercial Court of England and Wales.
Anyway, I digress. This decision's all about jurisdiction, and we've got a typical situation in many ways that Calum and I have handled on many occasions, where you have a charter party dispute between owners and charterers, albeit in this case not a great deal of money in dispute. I think the claim brought by the owners was for something around $100,000. for balance at the end of a charter party. And so they had a substantive claim, a contractual claim arising under the charter party against the charterers, and then wanted to get security for that claim against the charterers. The charterers had, it was alleged by the owners that the charterers beneficially owned another ship, the Polar Devourer, and went and arrested that other ship on the basis of this alleged beneficial ownership in Gibraltar, and did that to get security for their underlying English charter party claim. But Polar, in defending that arrest in Gibraltar, flashed a time charter party between the entity that was the chartering entity on the DIVINEGATE charter and the actual registered owner of the Polar Devourer vessel, and argued that they were not the beneficial owner of the Polar Devourer. They were instead the time charter of that ship. The claimant owners in the English proceedings then kind of stepped away from the arrest and let the arrest be lifted, albeit not conceding that the arrest was wrongful, and not conceding that the Polar entity, who were the charterers on the DIVINEGATE, were not the beneficial ownership. They were maintaining that they still are. And so the question then came before the English court, because the charterers of the DIVINEGATE, they brought the claim for wrongful arrest, saying that the owner should not have arrested the Polar Devourer in Gibraltar. They had no grounds to do so because they were not the beneficial owners. And they then, in the English proceedings, brought a counterclaim for underperformance, so substantive contractual issues in response to the claim. But they also brought a counterclaim for wrongful arrest, which was a tort-based claim, and there were a number of formulations of the tort for wrongful arrest. And the decision for the English court, and we had Patricia Robertson QC sitting as a deputy judge and gave judgment on this issue only last week. The issue before the court was, does the English court have jurisdiction to consider the tort claims for wrongful arrest?
Precisely. And I guess the key, what was happening here was that the vessel, having been arrested in Gibraltar, essentially the wrongful arrest claim was used as a lever against the claimant's claim. So the defendant was saying, not only do we resist your claim on a substantive basis, but also we have this wrongful arrest claim that we want to bring against you. And it feels like the claimant, probably for tactical reasons, was saying, no, we'd rather this was a bit more difficult for you. We don't want you bringing your wrongful arrest counterclaim in England along with everything else. If you want to bring a wrongful arrest claim, you're stuck with Gibraltar. You've got to bring it there. And it's going to be more costly. It's going to take more time. And you can see the strategic or tactical benefit in the claimant trying to punt the wrongful arrest claim off to Gibraltar.
Yeah, and it's one of the considerations I have, having read the decision, seeing Robson QC, his deputy judge's comments about the costs, and a few of the criticisms about how the expert evidence was being handled, whether this case actually runs, because now you've got a situation where owners have a claim for $100,000 odd. Charterers have a substantive claim for $150,000 odd, another $50,000 odd dollars for wrongful arrest, as well as costs on the application. And this is going to be one of those cases where, and it's all to be decided now in England, there's still a large number of open questions, which we can get onto substantively. But the cost considerations here, it's just screaming out for a case to really resolve and resolve quickly.
It is, and I think it's something that we're seeing, part of this exercise of reading the judgments, particularly English court judgments. We're seeing this question of costs being reiterated by judges, or here by Patricia Robertson QC sitting as a deputy judge. They're making the point, is this a case that requires the use of court time, the use of a public service within the UK? And I think there's a distinction there in costs between court and arbitration proceedings, and the court will really push for settlement. I've seen judges before. I think it was one of the cases that we've discussed in this podcast, expressly saying that litigation is not a particularly satisfactory way to resolve a dispute. It's very binary. It tends to make positions entrenched rather than to find a kind of commercial resolution that people are actually happy with, and it's not a particularly commercial way to resolve a dispute. It simply lends itself to a binary outcome and really should be seen as a last resort. That is coupled with the fact that the court very much sees itself as a kind of public service, and you shouldn't unnecessarily demand public services where parties have an opportunity to settle a dispute. And we see it here, we see it in other cases. For example, we saw it in the Ferrari case. The judges in the English courts really won't hold back from telling the parties that they ought to have settled the dispute where they feel like the dispute would be better settled than litigated.
Yeah, and in this case, there was a BB Energy Gulf criticism made as well in respect of expert evidence, because expert evidence was adduced by both parties. Remembering this is an application on jurisdiction. Expert evidence on Gibraltar law was adduced by both parties without the court's permission. And the expert evidence that was adduced went far beyond the questions or the narrow issues of jurisdiction and introduced all sorts of other things. And so the court found it necessary to express a quote, even-handed criticism of both sides, close quote, and that's regardless of who fired the first salvo. And by that, the court really means that parties need, and their representatives need to think carefully about the procedural steps that they're taking in court, and not to incur additional costs and take additional steps that are not strictly necessary. And if they are going to take steps like, adduce expert evidence, then it needs to be done with the court's permission. And it's interesting how many of these cases we end up discussing the substantive points, but we also discuss matters of procedure and how cases are handled. And it's always a good point to reflect on that. At each step, when you're about to do something, particularly when you could see what happened here, Calum, we've had cases like this where the other side puts in an expert report, and then you feel this compulsion that we've got to get in our expert report, and we've got to respond to it. We've got to respond to it robustly, and we can't let any point go unanswered. Where actually the stronger position in this case may well have been to just sit back and say, no, we don't need expert evidence, and indeed we'll stick to our guns that it's not been put in with permission.
I couldn't agree more. And I was going to say when you were noting the fact that the judge gave this even-handed criticism of both sides, it's hard not to feel sympathy for the practitioners involved, because it's that situation that you're talking about where suddenly the expert evidence appears. Suddenly you have this these points on record, and even if you think to yourself, this doesn't go to an issue which is before the court for this application, there is still that voice in the back of your head that says, but I need to respond to it just in case. Because you'd almost rather have the criticism in the judgment for giving too much expert evidence than lose the case on some grounds where you just didn't put forward your position fully or backed by expert evidence.
Yeah. So just shifting gears a little bit, coming on to some of the jurisdiction questions here. The ultimate decision was that spoiler alert, the ultimate decision was that the English court did have jurisdiction, and we'll skip through why that was in a moment. But the decision was that the English court had jurisdiction and has jurisdiction to consider the tort claims for wrongful arrest. And so not the jurisdiction, and that's not necessarily exclusive. So the claim could also be brought and pursued in Gibraltar for the wrongful arrest as well. But there is a kind of threshold, kind of jarring point to this, I find, Calum, in that you've got the Arrest Convention of 1952, which usually does put the question of a wrongful arrest or issues with the arrest to the jurisdiction in which the arrest was made. But here, in this case, we're not dealing with the Arrest Convention. We're dealing with the Brussels Convention 1968 and going through specifically through the articles of the 68 Convention.
Yeah, exactly. And one of the parties, the defendant, was domiciled in Cyprus, which is a contracting state. So they pulled in the Brussels Convention, 1968. I noticed that it's not the Brussels Recast Convention; it's the original 1968 convention which applied here. But you're right; there is that tension between the result that you get by applying the Brussels Convention and the Arrest Convention, which fairly straightforwardly says that these questions of whether the claimant is liable and damages for the arrest of a ship are to be determined by the law of the contracting state where the arrest was made. And
there's really three key questions that flow from looking at the convention, but even there's a question prior to the specific articles of the convention. So the first question is about the scope of the jurisdiction clause in this charter party. The second question is then whether Article 21 of the convention means that jurisdiction should be declined by the English courts, even if it comes within the jurisdiction clause and referred over to Gibraltar on the basis that they're the same cause of action. And then the third question is about Article 22 and whether the English court, in applying its discretion, should send this claim over to Gibraltar and decline or stay jurisdiction in England because it's so related to issues arising under the arrest claim that was brought by the owners in Gibraltar. So those are the three questions. I think we can deal with the last two quite briefly. But first, Calum, should we just focus on that first question and the wording of the jurisdiction clause and what falls within and outside of that jurisdiction clause?
Yeah, so I have the jurisdiction clause up here, and it reads, "This charter party shall be governed by English law, and any dispute arising out of or in connection with this charter shall be submitted to the exclusive jurisdiction of the High Court of Justice in England and Wales." And I think what's interesting, having read through this case, is that the way that these clauses should be interpreted. In the case called the Fiona Trust case, essentially the law, there was quite a kind of finicky approach to reading into each and every word of a law and jurisdiction clause. and saying, are we looking at are we looking at disputes arising from, or are we looking at disputes arising out of? What do each of these words mean? And that was kind of overhauled by the Fiona Trust case, and they really took maybe a more general, purposive look at what the intention of the parties was in drafting these dispute resolution clauses. And I think they called it a fresh start in the way that they were intending to read these clauses, and in doing so, they kind of implicitly overruled the prior authorities, and that was critical here.
Yeah, and with that said, there are still some words that can have distinctions. So, you've just said arising under, arising out of, arising over the moon. Well, all these kind of arising unders or arising with respect to that contract. The distinctions there are so fine that it doesn't make sense to try and draw those differences, and that's what you're talking about with the Fiona Trust principle. But there is a difference between something that arises under a contract or out of a contract and in connection with. And this language, in connection with, does mean something broader than simply rights and obligations arising out of the particular contract. And that's where the court went in this case. So by including those words in connection with, the parties are saying that they want to include potential disputes beyond merely the rights and obligations arising out of the contract. And it was on that basis, that construction of in connection with, that the court then found that the tort claims, and remember, these are not tort claims that run in parallel with contractual claims under the original Charter Party. The tort here is the tort of going and, alleged, wrongfully going and arresting a ship that doesn't belong to the counterparty. And that tort in getting the wrong beneficial owners, alleged wrong beneficial owners, it is a tort that is in connection with the contract, but it's not a tort that originally arose out of the contractual situation that the parties had for the shipment.
Completely. And I think when if you step back and you say, okay, what's happened in Gibraltar? Well, there's been an arrest of a ship, and the arrest of the ship is an attempt to obtain security for sums that are said to be owing under this Charter Party agreement. And the arrest, there's an argument that the arrest is wrongful and that there's been some losses suffered as a result of the wrongful arrest. It seems to me that that's quite clearly in connection with the Charter Party. You have a dispute under the Charter Party which leads to a requirement to, or an attempt to obtain security. The attempt to obtain security causes loss. Is that loss in connection with the Charter Party? Clearly, yes.
Mm. Yeah, and did you pick up that the court found further support for this view in London Arbitration 8/04 from 2004, which was a decision of the ad hoc arbitral panel, a London panel, and it was looking at whether claims for wrongful arrest fell within the scope of an arbitration agreement. And the tribunal in that case found that the owner's claims formed, and I like this, if not a seamless web, then at least a thread that was sufficiently continuous. And then that decision was appealed, and the High Court refused leave to appeal on the footing that the decision was not wrong, let alone obviously wrong. So I thought that was a good point, that there is some tacit support for this kind of construction.
I agree, and it shows that there is some persuasive authority in the London arbitration reports. I know we've dealt with one of them in this podcast before, and I'm sure there'll be more that we deal with in the future. But it shows that they are persuasive. I also thought it was. I googled Patricia Robertson QC. She's not a QC that I've seen a number of times in the kind of shipping and international trade world. And it looks like her core practice is highly commercial, but it's not in those sectors. And I thought it was actually quite well done. The judgment to look through various shipping cases. Obviously, anyone who's involved in law is aware of the shipping industry because there's so many cases on shipping. But drawing support from things like London arbitrations, drawing supports from a number of cases that deal specifically with jurisdiction clauses in charter parties. I thought it was a well done and well written and comprehensive judgment.
Yeah, I entirely agree with that. I entirely agree. And the court also looked at some non-shipping cases and looked at Ryanair and Esso from 2015. Where the clause used the language under this agreement and drew a distinction with that and in connection with. And I think that must be right, just from a contractual construction point. If you're looking at that clause, in a vacuum, Calum, and parties have said arising out of or in connection with, you would expect the in connection with to mean something different than arising out of, and a plain English meaning of that must be something broader, I'd have thought.
I agree, and it touches on one of the questions that I had reading this judgment. Is it the case that there's a different method of contractual interpretation for a law and jurisdiction clause? I suspect there can't be. I suspect that cannot be the case. But the Fiona Trust case is obviously the leading case for the moment on interpreting a law and jurisdiction clause, and I think it's 2005, the Fiona Trust case.
Yeah.
Since
that long, wow, time flies. I can
remember
that coming out, and
really,
writing bulletins about it at the time. So anyway, sorry.
Well, exactly. But since then, there's been a number of developments in the law of contractual interpretation. I think since then we've had Rainy Sky and Cookman Bank, we've had Arnold and Britton, Wood and Capita. We've had a number of leading judgments on how contracts are to be interpreted, and I don't see why those principles wouldn't apply to interpreting an arbitration agreement or an exclusive jurisdiction provision. I guess equally, I don't see any particular tension between those judgments and the decision in Fiona Trust, 2008. Sorry, correct record. You're not quite that old, Luke.
That rings. It must be around 2008. Yeah, that sounds right. Well, I'm thinking where I was at that time, and that makes more sense. Okay. Yeah. Well, look, on the point about whether jurisdiction or arbitration clauses should be construed differently, I don't think so. I don't see there's a reason for that. But I do wonder whether they get more scrutiny because they are the type of clause that appears in so many contracts. So there can be so many different formulations of parties trying to achieve the same thing. So you might have all sorts of contracts, right? You're dealing with different subject matter, but you still got a law and jurisdiction clause, or you still got an arbitration clause. And then you get these, just drafting points where lawyers use slightly different words to try and achieve the same thing. And then you end up with a bunch of decisions where the words are slightly different. I think Fiona Trust is saying, well, the intention here is usually not commercial parties trying to distinguish from one clause to the next, if the wording is only slightly different. But where there's something quite deliberate or something that looks significantly broader, which in connection with does compared to arising out of or arising under, and that does mean something. And there is a commercial point to this as well, I think, that it allows for one jurisdiction. Well, I think they said in this decision, a single accounting type principle. And I thought there was something to that as well. So, yeah, that's where we ended up on the first question. So the upshot is that the tort-based claims for wrongful arrest did fall within the original jurisdiction clause, and the courts had no concerns, and indeed said that we think it's reasonable to say here that at the original inception of the contract, when the parties were putting together this jurisdiction clause, that they would contemplate a claim for wrongful arrest, say in seeking security, falling within the ambit of the original jurisdiction clause. So that got into the kind of jurisdiction gateway in the English court, and then the question was, well, does the Brussels Convention 1968, which was the applicable convention here, does either of its articles, Article 21 or Article 22, mean that the English court should decline jurisdiction? And do you want to just give Article 21 a quick touch on, Calum?
Yeah, and I don't think we need to dwell on it too long, because the answer was given quite shortly by the judge, and the answer is, the question under Article 21 is, are these proceedings involving the same cause of action and between the same parties? And the court said no. The court said that in Gibraltar you had an action which was an arrest action for security, and in England you now have a tortious action, which is based on a number of different tortious law principles on the basis of wrongful arrest, and those are not the same cause of action, so Article 21 doesn't apply. Yeah.
In that section, though, there was an interesting paragraph that I had to read a couple of times, I must confess, paragraph 71. And this wasn't an issue for consideration on this application, but that is, what is the actual governing law of the wrongful arrest claim? And I put that as a question to you, if you've thought about that, Calum.
It's a good question. It strikes me that it depends where you bring it. And if you're bringing the wrongful arrest claim in Gibraltar, then you'd make your arguments that Gibraltar is the governing law of the arrest. And if you bring it in England, in the various different tortious formulations that it was brought in England as a counterclaim, then you argue that it's an English wrongful arrest claim.
Yeah, and that's where I don't know whether you look closely at it, but in paragraph 71. It's this point where Patricia Robson QC, where the deputy judge said that the wrongfulness of the arrest must on any view be a matter of Gibraltar law, but then went on to say, whether the damages claim is also governed by Gibraltar law, and involves establishing malice or gross misconduct, or whether, as pleaded, it is governed by English law and requires proof of the additional elements involved in the various torts on which the defendant relies. So from that, looking at it from the charterers, so the defendant's perspective, who are the counterclaimants, they must be pleading that this is an English law question, so that they only have the additional elements required under English tort law, and don't have to establish the malice and gross misconduct, which might be under the law of Gibraltar. But anyway, I just thought that was quite an interesting point. And if we were on this case, and the parties were then looking to try and resolve it, you can see how that type of issue may be quite instructive on, the settlement dynamic and some of the arguments that are going to be had to try and resolve this, assuming that they do after this try and resolve it.
Yeah, and I think that the key point there for the defendant and counterclaimant bringing this tortious claim is that they have to show that the arrest was they have to show that there was no entitlement to arrest that vessel, and because the vessel was arrested in Gibraltar, that's a question of Gibraltar law or Gibraltarian law. And it then goes into this question of damages, and improving your damages is that second question a question of English law or Gibraltarian law?
Yeah, exactly. So I might just take the last point that was before the court on Article 22. And this was whether the English court should stay or decline jurisdiction in favour of Gibraltar, because the wrongful arrest claim is related to the arrest claim. And if so, it becomes a discretionary matter. Should the court decline or stay jurisdiction if they are related? And the court ultimately decided here that that they were related because there was overlapping issues, although those issues were only limited, again, between the arrest and the wrongful arrest. And there was a risk of irreconcilable decisions, a low risk again, but a risk nonetheless. So Article 22 was engaged, but then the court decided, well, I am going to exercise my discretion to allow jurisdiction. And the reasons in very short form for that decision were that the issues that overlapped were only limited. The claim in Gibraltar for wrongful arrest was barely out of the starting blocks, so it really hadn't been progressed. The arrest had been lifted in Gibraltar, and it was unlikely that the wrongful arrest claim in Gibraltar was going to be re-engaged. Feasible, but it seemed unlikely. And while the wrongful arrest claim may involve, and probably will involve, questions of Gibraltar law, the court had no difficulty saying that can be dealt with by expert evidence, and noted that Gibraltarian Admiralty law mirrors English law, English Admiralty law. So that wasn't a strong reason against using its discretion. So for those reasons, the court found that the wrongful arrest claim fell within the jurisdiction clause, and under Articles 21 and 22 of the 1968 Convention, jurisdiction should not be declined.
Yeah, and I think it's the right decision. I think if you look at to me, it all goes back to the exclusive jurisdiction clause. The parties have agreed a broad law and jurisdiction clause, and I think it's right to say that commercially they would have anticipated at the time of signing the contract that these kind of satellite disputes would be pulled in within that law and jurisdiction clause. And I also think that I don't think there are particularly good reasons for it to be held in this decision to be taken in Gibraltar. It's really common that we see security actions in a place that is different to the law and jurisdiction clause, because the law and jurisdiction clause requires the parties to choose one jurisdiction which is going to have jurisdiction over all the disputes that arise out of the contract. And then the moment that you're seeking security, you obviously don't limit yourself to seeking security within that jurisdiction which you've agreed is the jurisdiction for resolution of all the contractual disputes. So you have to look further afield, and it's entirely normal to look somewhere else and to say, okay, we're going to arrest a vessel in South Africa, in India, in Sri Lanka, in the US. And I think that parties, particularly parties in the world of international trade, wouldn't see any real tension between having a security action somewhere and still having all of the disputes pulled together in one main action, which is subject to the agreed law and jurisdiction in the contract.
I agree. I couldn't agree more. I think that's a good summation of how I see it too, Calum. Well, thank you everyone for listening in. I hope you found this talk today of value and interesting. I sure did. Thanks for your time, Calum. Always a pleasure. And if you'd like to follow us, you can do so in the usual places on Apple Podcasts or Spotify. Click that follow, subscribe button. We'd be very grateful if you did. And we'll have another episode for you next Thursday.
See you next week.
Thank you. Goodbye.